I make this for you.
It's Big Sam presents Raw.
I make this for you.
It's Big Sam presents Raw.
I make this for you.
It's Big Sam presents Raw.
I make this for you.
Big Sam presents Raw.
I make this for you.
It's Big Sam presents Raw.
I make this for you.
Big Sam presents Raw.
I make this for you.
It's Big Sam presents Raw.
I make this for you.
Big Sam presents Raw.
I make this for you.
Big Sam presents Raw.
I make this for you.
Hi, would you like to sponsor this show? You have the ability to sponsor Big Sam Presents Raw and or Shit Talk. I don't give a goddamn. You could pay me $100 a month or $50 a week or $250 every 2 weeks. Regardless, it don't even matter. If you want to sponsor this show, you can. Let me know. I'm Big Sam, and you got the opportunity to sponsor this show. This show, goddammit, this one. Are you not entertained? Fuck you, because I wasn't trying to entertain you. Bye, bitches.
I make this for you.
Can we let them know that? Guys, your mics are alive, so we can hear you. Can you hear me?
Yes.
It does.
A basic volume control.
There's a knob on the speaker. You just need to adjust it.
Yeah, it's just adjusted down a touch. Although given Mr. Evans' history with this.
Do not.
I hate to say that there are similar transactions on here on.
Okay, we're back on. Everybody is present.
Thanks. A life well lived, of service to his community, earning the respect of respectable people, committed to his marriage vows through thick and thin, with absolutely no criminal history and not a single complaint ever made in his 64 years on this planet related to aggression, violence, or disparate treatment. The defense has met our burden of production on the 4 Ayala factors in overwhelming measure, Your Honor. Roots in the community that are long and deep, length of time in the community, lack of criminal history, and good worth for decades to this community. He's not a perfect man. No one is. Health and finances required him to have some blips in his training record that he addressed appropriately through the measures that the post director told you gave him the right, and because it was a notable situation of a medical condition, to get those waivers of exceptional circumstance. I take great offense to Mr. Evans' comment that we're just up here talking about history, and that's just the past, Your Honor. That just couldn't be any further from the truth. History is the only reliable measure of a man's character. It's the only accurate predictor of future behavior. It is not, as the state characterizes it, a distraction. It's not smoke and mirrors. It's the basis, the foundation of the evidence you must consider in evaluating the factors. So, after an overwhelming presentation of those factors under Ayala, what has the state done to attempt to rebut that? Let's talk about the factors one at a time. First, is there evidence of significant risk of flight or failing, or concern of a failure to appear in court? The state's argument is that the strength of that the seriousness of this offense, and it is the most serious offense you can have, coupled with some potential DOJ investigation, is enough to persuade this court that Greg McMichael will not be in trial. But what we were able to show you, Your Honor, without trying to try our case, but simply providing the rebuttal to you of why Greg McMichael has no desire to be anywhere on the day of his trial but right here, is because we have a strong defense. This case, despite all that we've heard, is about whether Greg McMichael, on February 23rd, was authorized to protect his neighborhood against crime the way that he did, to do the good deed that he describes on the phone, of putting himself out there to protect his community. This case is about self-defense and whether under the private citizen arrest statute and the justification statute, as Greg McMichael believed he was, whether he had the right under the law to arm himself to attempt to detain a person he believed, as you hear in his interview, with 100% certainty, and in fact he was right, was the person the police had been coming over to their neighborhood to try to detain themselves. A person who was coming into a home under construction day and night, followed by reports of things having been stolen from that home. People of good character who have a significant stake in this community, Your Honor, came before this court and told you Greg McMichael will be here. He needs his trial. He's a man of his word with over 30 years in law enforcement, with a wife he loves, and a grandson that he adores. But not only did they just tell you this, Your Honor, they put their money where their mouth is. They provided to you evidence of hundreds of thousands of dollars of unencumbered property that they will stake that belief on for this court, knowing the ramifications if their friend, former colleague, respected member of the community did not reappear for court. And you also heard why else he's not going anywhere but staying here in Glynn County. After 2 heart attacks and a stroke, his critical life-saving needs to continue to see his cardiologist, his neurologist, and his GI, to be able to be home to get that loop implant wired back up to that black box that will let anyone know if AFib, atrial fibrillation events are occurring, so that he doesn't sustain another stroke, are the reasons he will have to stay in Glynn County if released on bond. Danger to persons or property and the danger of committing a new felony. We're going to put those together. And what does the state say to you? Despite a lifetime of nonviolence, the state says, it's the case, Your Honor. It's our case. Watch the video, and you will be persuaded of a predictor of future behavior. Well, Your Honor, that's just not realistic. A man does not wake up one morning and become a violent, race-motivated killer. That's not how it works. With no complaints in his past, no evidence of some history of violence, to do what the state continues to characterize this case as hunting down another human being in his neighborhood. The video that they chose to play shows this court any number of opportunities for a race-motivated, hating, vigilante murderer to have shot down Ahmaud Arbery dead in the street. If it was for the act, some supposed happiness or glee, desire to be that sort of person, you have a video that shows you all the opportunities someone who would be that sick and awful would have taken, could have taken, to have murdered Ahmaud Arbery. In fact, you see that Greg McMicheals doesn't even take his gun out of his holster until Ahmaud Arbery bolts left and attacks Travis. But the state says, no, that's not the man. All you've heard of him, it's not the man you should think he is. Because after going through thousands and thousands of pages of Facebook history, we, the state says, found a couple things on his Facebook page. Can't tell you whether he saw them. Can't tell you whether he liked them. Can't tell you whether he commented on them, thought they were great, thought they were horrible. And these, Your Honor, one post on April 17th, 2019 that has the word Identity Dixie on the bottom of a picture of 2 children, that is what they're asking you to make this enormous leap from, to now make Greg McMicheals into a racist murderer. That is not how justice works. That is not how this courtroom should work. And then, of course, the bombshell at the preliminary hearing. The effing N word that only came up in Roddy's fourth interview, after trying desperately to work with the police, Roddy Bryant, to get out of any criminal exposure in this case, is when you heard at the preliminary hearing, or you read in that transcript, that Roddy Bryant said he heard that. Even though you now know with the 911 call that Greg McMichael made that we have in evidence, the line remains open. Even to the time the police arrive, and you hear nothing from that phone in the cab of the truck. But race, the state says, and racism is what should make you be afraid to release Greg McMichael on bond. I don't want this to sound flippant, Your Honor, but to hear the state talk about this case, from the preliminary hearing to every court filing in the case to this hearing on bond, you would think that the race of Ahmaud Arbery is the only thing that makes the state of Georgia concerned about a serious event on February 23rd. That if in fact this was Arnold Arbery, a young white man who'd been repeatedly seen in Satilla Shores, a neighborhood on edge from repeated crime, caught at night on video more than once in a home under construction where items then went missing. That if Greg McMichael saw Arnold Arbery, chose to follow him in hopes of detaining him so that the police could get to the bottom of these crimes, but then Arnold took a left and attacked his son, forcing Travis McMichael to turn into a killer. That the state just doesn't sound like they'd be all that riled up about it. This case isn't about race, Your Honor. This case in the indictment is about whether or not the private citizen's arrest law and the justification statutes allowed Greg McMichael to do what he chose to do that day for the sole purpose of defending his family and his property and his community. And finally, the state, under the fourth Ayala factor of a risk of influencing witnesses or otherwise obstructing justice, points to the ally phone call that he has with his brother. Well, Your Honor, the antonym of ally is enemy. And as we're all aware, in this day of cell phone access, there are plenty of cell phone videos taken by onlookers whose sole purpose is to try to say that the person they're taping is doing something wrong. Ally means no. This videotape, as horrible as it is to watch, is exculpatory. It is the only proof of what Travis and Greg McMichael said at the scene immediately, and that is he attacked Travis. Who could ever believe that had there not been that videotape? That's what that word means. The state says that the minute the officers arrived on scene, Greg McMichael told them that he was an officer, and I'll use their characterization, in the hope that it will impact how the case would progress, inserting himself into the investigation. Your Honor, here are the clips. I'm not a danger to you right now. That's the point of him telling all the various reasons he's saying it, let alone the adrenaline that's running at the time that this has all happened. His context is, you don't need to worry about me. I've been where you've been, ladies and gentlemen with uniforms on. I'm not going to run. I'm not going to hurt you. I'm not going to bow up when you try to get evidence from me. I understand, the quote is, that you've got to do a full investigation. I'm going to comply with what you need from me. And then the fourth time is when people who begin to recognize him. Right. Yeah, we knew each other from the police force. Not an attempt, hey, come on, between you and me, just let us go. There is no evidence that anything Greg McMichael did or said on the scene had any impact on it, and nor did he seek to, in the proper context of those body cam videos, did he seek to do anything to get or curry any favor. And then the phone call to Jackie Johnson, his former employer of decades. They played the one. Now here you now have into evidence the second one. Hey Jackie, this is Greg. I have retained Alan Tucker. Took your advice. I think Alan's going to do me a good job. And then he goes on to thank her so much for your advice. Because who else, who better knows how to seek help in a criminal case? Who knows the criminal defense community but the district attorney? There's no suggestion that he's seeking to get some help from her. Cover me here, Jackie. Help me out. Keep me informed of the investigation. Put me on the back burner. Absolutely nothing like that. The other thing they cite as and the obstruction of justice is Greg McMichael's emotional request to his wife to get his daughter off of social media, to take down that tasteless post of a crime scene. She wasn't posting anything. She didn't have any evidence to seek to get rid of. It's his daughter who did a thing that he found offensive, and he wanted his wife to make sure that she didn't do things like that again. And the telephones, as you heard, were already gathered by the investigator, by Lee McMichael, given to the investigative team that then went over to Agent Dial. Agent Dial testified at the preliminary hearing. Nothing was scrubbed. They took everything. Everything was clean and orderly, just as you would expect a former law enforcement officer to do, because he respects the law. And then the affidavits that we introduced in the case in chief of the surrounding neighbors to say to this court, Greg McMichael is doing nothing to influence me, to intimidate me. Nothing will change about my testimony if Greg McMichael is out on bond. The state characterizes that as a campaign to influence witnesses, to talk to your neighbors in the months that you're home after this horrific event in your community. All the neighbors that had been on edge, who'd been trying to put their heads together to decide how they're going to handle this continued crime in their neighborhood. And then the last was some postcard of gobbledygook, and that sent out to his son's friend, and some suggestion by Emmanuel that he must have known the rules and chose to break them. That's not a rebuttal to the significant evidence in support of those factors, Your Honor. Jesse Evans said to you in the beginning of his argument, bond as a matter of right. Well, that's really not an accurate representation of what the statute's all about. The phrase bond as a matter of right refers to cases that are not indicted within 90 days. And they sure did get this indicted within 90 days. Bond as a matter of right means, Judge, you don't have any discretion. You've got to give them a bond. Yes, of course. This is not a case of bond as a matter of right. But here's where the state has mischaracterized it from there. Outside of an instance of bond as a matter of right, liberty is the norm. Detention is the limited exception. The purpose of a pretrial bond is to prevent punishment before a conviction and to secure the appearance of the person in court for trial. Otherwise, Your Honor, what we're doing, if you have not been persuaded that Greg McMichael poses a significant risk of not being here or becoming the man he never was before and becoming a dangerous man suddenly in the 64th year of his life, or to intimidate witnesses after a life of service to law enforcement, if you have been persuaded that that's not what's going to happen, that he'll be here and he'll be safe out there, then your not setting bond is simply beginning his punishment. He spent 6 months in the county jail and respectfully waited until we could get the pandemic to a place where we could have this hearing. He is a worthy candidate for bond, despite what you hear from the state. And in fact, he does not give you the significant, compelling, and legitimate government need to deny him his right to liberty and freedom so that he can defend himself against these charges. Please, we ask you to set a bond in a reasonable amount that can be secured by family's property and to allow him to go home to work with his lawyers. Thank you.
Thank you. Here is what I plan to do at this point. Let me find or figure out where we are on some of these remaining issues. So I want to digest a few things before I get to the point where the court rules. Bond is not the only issue before the court for this hearing. Also before the court were the special demurs filed by all three defendants, a motion for a joint motion for the deposition of Larry English, the state's motion for an ex parte hearing, and then, as I said, there's a motion to adjourn the state, which the court has already ruled upon. With regard to the special demurs, are we having legal arguments here today? Is there additional evidence that the parties intend to present? Probably this is the thing to start with defense.
We filed two on behalf of Greg McMichael and Travis McMichael joined in those. There's no evidence to present for either of those through this legal argument. And quite candidly, the legal argument I can make here will not expand on what I've written. But I'll be glad to engage in a conversation about it if the court would like and discuss the issues I raised. Or if I've written anything that's not clear, I can clarify. But there's no evidence required for these two members.
And Travis McMichael is joining, and I believe also Mr. Bryan is joining.
Yes, I would not add anything to another argument that Michael sent on those two demurs. No, I'm sorry.
You're both nodding your head. I didn't want to remind you of the court reporting.
We join in.
And from the state?
Yes, Your Honor, Linda Dunacasti for the state. The state is in the that you should go ahead and rule on the written motions that we submitted in response to the mistake.
All right. The report's outlined the demurs, but what I wanted to make sure of today was that beyond what was submitted in the briefs, there's going to be no additional legal argument or evidence for that matter. That being the case, and understanding that from the sounds of things, everybody's willing to rest upon the briefs, I'll just move forward then with what I've outlined and go through the legal issues that have been presented. So at least for the purposes of today, I'll address that upon the briefs with no further action at this hearing. Okay. There is, let me address this one because I think this is pretty straightforward. It was kind of an odd filing, at least as far as I was concerned. The state's motion for an ex parte hearing. This had to do with what has occurred in this case. There have been a number of joint filings on behalf of Greg and Travis McMicheals. I mentioned yesterday, I think, this case, as much as it may seem at times that I get frustrated with the amount of lawyering that's going on, one of the things about this case that is a positive is that we have experienced lawyers that know how to try a case and know how to get a case ready. And I say that because I'm not sure I really want to get into an ex parte hearing on conflicts of interest. I trust, and unless I hear otherwise, that counsel for Travis McMicheal and Greg McMicheal are fully aware of their professional obligations to their clients to the extent that it is necessary or has been necessary, and I don't want to know because I don't want to get into any contact between clients and their counsel, any privileged information, but to the extent that their clients need to be informed of whatever the defenses are and what type of decisions are made with representation, I assume they've been fully informed. Unless I hear otherwise at this time, I'm going to assume that has occurred. Fair enough?
Yes, sir.
Yes, sir. Thank you very much.
That's the way I will address that motion. I'm not going to put anything in writing. I believe that by bringing it up in open court with clients present by video conference, that I've touched upon what I need to touch upon on that motion. And I've got a joint motion for the deposition of Larry English. What I'd like to hear is what it is, and I've read the brief. It's rare to take the deposition of a witness like that. There's no indicate, although there's some medical issues out there. We don't have a trial date, and I don't have any acute issue that I'm aware of that demand that the court move forward. But I'll hear from the defense as to why this is being brought up now.
Yes, sir. And I believe in speaking with the state that they join in the motion. They would also seek the deposition. It is my understanding from speaking to his counsel that he has a serious, significant heart and lung problem as outlined in his doctor's letter, that he is at risk of getting COVID-19, and if he does, then he'll have some serious consequences as a result of underlying illness. He's a high-risk patient. And so, given that we don't have a court date, and we don't expect to have one anytime soon, it will be 2021 before we do, we fear that his condition could worsen to the point where we can't get critical evidence into the record. And I think the state feels the same way.
So it may very well be that we acquiesce in this motion at some point. I do have an update from Monday, and I appreciate the fact that we've been able to have this dialogue from the attorney that represents Mr. English. She texted me late Monday night and says that Larry English has an appointment next week. I don't need to give the details on that, and she would like to follow up with us on that. So subject to me getting more information after next week, if we could revisit this with the court. I just don't think that right now there needs to be an argument or a ruling from the court. Let us, if it's okay with the court, to continue to talk about this issue to see if there's some agreeable ground. But I won't know more until probably the 19th.
And that's fine. We've been working well. I've talked to Michelle before, and I've talked to Mike before. It's not much of a consternation. So I'm happy to continue the conversation.
Okay.
And it's maybe well.
Okay. Well, it's always good to hear the parties are discussing things. Obviously, with a deposition of this nature, the court's going to need to get in the loop if this gets along in the park. There's a lot of questions I have about how this would occur and what needs to be done in order to get the court to a comfortable place on it. Okay. But I understand I believe those are all of the matters that were on the court's notice of hearing.
Yes, Your Honor, we wanted to ask for one additional issue. In the court's scheduling order, you set our motions deadline, the defense's motion deadline, for the end of this month. I think when the order was set, none of us probably anticipated we'd be spending a couple weeks in November getting ourselves ready for the bond hearing. Probably figured we'd have done it much earlier. But this has taken a considerable amount of time, and we're going to be moving right into the holiday, the Thanksgiving holiday, and for all four lawyers, we've had to put a lot of things on the other cases on the back burner. We each have an incredibly busy week next week to do the things that we had to put aside. We've spoken to the state about this. They don't seem to have any opposition to our request for at least another 30 days and to make it till December 31st for us to get to you our pretrial motions. The other important piece is that while the state has given us almost all of the evidence, there is still evidence outstanding from the state, they've told us. So until we've received everything that we need to review, we'd like the opportunity to have a little more time.
First, so that the record is not silent on this, I don't recall whether we discussed it or not. We did have a scheduling conference remotely with the court, which I think was beneficial, so I want to perfect the record on that, where the court essentially offered to conduct this bond proceeding earlier, but remotely, and it was decided by the defense strategically that it was their opinion that doing it live would be beneficial to them. So I want to make sure the record's clear that since delay was brought up, that the court was willing, as was the state, to do it earlier, but it wasn't feasible, which is completely understandable from the defense's perspective. That's their strategic right. So second, it is accurate that I do not have some things to turn over in discovery. We're talking about digital forensics. I have obviously a lot of digital forensics, but it's been complicated by, I won't get into the details, but ability to get into certain devices and passcodes and things like that. So I personally don't have it. The GBI continues to work on that, and we continue to be in communication weekly about getting that. So it is correct that there will be some additional discovery as soon as we're able to bypass those devices and get to it. Third and finally, I think scheduling orders are extremely beneficial. We appreciate it, Judge, but I think we've also seen that as professionals, we can talk through issues and, where feasible, discuss whether there might need to be gentleman and gentlewoman's agreement about certain things. And I understand that there may be a necessity to extend some deadlines at some point. So I don't generally have an opposition to some sort of extension of time for filing of motions out of fundamental fairness, in light of the fact that I do not have some things that I need to turn over to them, and it's because of the difficulty in accessing the devices.
Sounds things there shouldn't be an issue in modifying the schedule.
Thank you.
So what I'll do, though, I'll need to get back into it. And look, what I'll do is push out. Most of those deadlines are connected. A lot of times those deadlines are connected because I have a trial date in mind. I don't have that at this point. So I'll push it out and see what deadlines we need to shift then in order to accommodate.
Very good. Appreciate it, Your Honor.
No, just to be clear for the record, we're not moving or changing today that's waiting Mr. Brian's speedy trial run. Subject to continuing conversations with counsel, things may change, but as it stands right now, we anticipate filing a plea tomorrow in the middle of January, which, whether we prevail upon that motion or not, is then subject to
Any other matters for the court?
Your Honor, I just need to give this to the clerk of the court. It's our flash drive, Exhibit 32.
Okay. Well, then the court, the last matter is the court's ruling on the motions for bond. The court heard a lot of evidence, and as indicated, I don't want to get into trying the case. And at this time, what I'm going to do, I think, is the easiest thing to move forward, is we're going to have to put a written order in place. Let's go ahead and rule and give a few, or touch on a few of the things the court heard from the evidence, and flesh it out a little bit more in the original order itself. So, that being the case, the court does not intend to grant bond as to Travis McMicheal or Greg McMicheal. Generally, with regard to Travis McMicheal, the court had serious concerns about a number of witnesses. Again, I'm just going to touch on a couple of things. There are other issues the court just needs to flesh out. At least the live witnesses, which was Travis McMicheal's mother, and then two, as they described it, best friends and spouses, indicated to the court that there was a significant concern about bias. What concerned me the most, though, was the consistency of the testimony, and then what I have to comment upon the record, what I found to be an absolutely indefensible explanation from one of the witnesses in open for one of the artistic exchange. That alone, was with regard to that one witness, in this one's mind, placed the rest of his testimony, including the consistency of his testimony, potentially other testimony, as indicated for the bias that exists with regard to those witnesses. As to Greg McMicheal, the court has some significant concerns about the fact that it does appear from the evidence that's out there that Mr. McMicheal was willing to place the law in his own hands, that felt that he had the ability to influence an ongoing investigation, and I think the facts are still developing on this, but possibly was one of the reasons why this case took so long to get to where it is right now. There was a comment, I think, during the closings about how there was no risk of flight if it was from February to May. He hadn't left. Well, I kind of see that evidence a little bit differently. To me, that's an indication that he just got very comfortable with the calls that were made to the DA and other things. So I think that evidence cuts both ways, and in this case is a consideration for the court with regard to bond. What's interesting about the facts of this case, I agree that the transcript from the preliminary hearing is the GBI's version of facts. Cross-examination based upon the issues that were presented in the preliminary hearing itself. But more importantly in this case, there's a video. There's a video. So one can look at the video, and I don't disagree with the response I'm probably getting mentally, which is, you can interpret the video in a number of different ways. But the video, to me, tells me that there's a significant risk, threat, or danger to the community. What I saw, I understand there's no, I'll look back to make sure that, because there was some reference during closings about how Mr. Arbery had been identified from prior videos. I don't remember the evidence, and that may have been argued, but there's nothing to indicate to me that he was known as the guy in the neighborhood prior to the day of the shooting, which tells me that an anonymous person was chased through the neighborhood to be detained for trespass and burglary. And that then somehow resulted in individuals believing it was appropriate to block that individual's path of travel, shoulder a firearm in order to get them to stop. There is a significant danger that all of those actions believe that the individuals that do that need to be aware of the fact that they can end up exactly where they are now. And that's not judging the evidence as to what we'll hear at trial, but simply looking at the video and taking, I think, a reasoned perspective on what we see. Then after that, the DA was called from the scene. There were a number of comments about the firearm being issued. Again, there are a number of different things that the court will place in its original order. I'm not going to get into the social media. I may touch upon in the order itself. I think that focusing too much on that social media at this point takes this case in a direction that I've been trying to indicate to the lawyers I don't want to take it in. But I may have to touch upon that in the order itself. That's just an outline of where the court's going to be going with this review. And that will be entered sometime. Today's Friday, hopefully sometime early next week. I'll make a review. Any questions from the defense on that, Travis?
Fairly shocked at not the ruling, but the reason that they didn't know who that was. So I just asked the court to look at it.
I'll look at it.
Your Honor, on behalf of Greg McMicheals, and perhaps on behalf of Travis McMicheals, I do think the court did make some misstatements of fact. There are a lot of facts in the case, and perhaps a review of the preliminary hearing transcript and the other evidence that was admitted.
I'm not going back into that. I just indicated to you that I've seen the video. I'm just pulling that out as an individual. I understand there's concerns about the transcript.
Right. No, I'm not trying to change the court's ruling today. I'm here to say that we'd like to submit a certificate of immediate review to you so that when you issue your written order, you may also sign that for us as well.
Appreciate the notice. I haven't drafted an order yet, so I think it's premature.
Nothing, Your Honor.
All right, those being all the matters then before the court, we are in recess.
Thank you.
Thank you, Your Honor. Safe travels.
Make a fool out of yourself, Jess. Everything I did for you. I did it because I love you. Thought you felt the same way about me.
Me? Love you? Bitch, you got to be crazy. I use you. You're a toy, bitch. A freak. You got a face on that mother could love, and she died, so she wouldn't have to look at it no more.
Hi, would you like to sponsor this show? You have the ability to sponsor Big Sam Presents Raw and/or Shit Talk. I don't give a goddamn. You could pay me $100 a month or $50 a week or $250 every 2 weeks. Regardless, it don't even matter. If you want to sponsor this show, you can. Let me know. I'm Big Sam, and you got the opportunity to sponsor this show. This show, goddammit, this one. Are you not entertained? Fuck you, because I wasn't trying to entertain you. Bye, bitches.